My name is Mary J. Virizales from OL22A44. My subject is criminal evidence. What is burden of proof? Burden of proof, also called as burden of persuasion or onus. Probandi is the duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. What is burden of evidence? Burden of evidence is the burden of going forward with the evidence. The difference between burden of proof and burden of evidence is burden of proof never shifts, it remains with the party upon whom it is imposed, while burden of evidence shifts from party to party depending upon the exigencies of the case in the course of the trial. What is presumption? Presumption, a rule of law stating because of basic facts exist and another facts also exist, it is inference as to the existence as to the existence of fact not actually known or conjecture based on past experience as to what core human affairs ordinarily take. Presumption, if uncontradicted, may stand in lieu of evidence and support finding or the decision. Two classes of presumption. Presumption in law is an inference as to the existence of a fact not actually arising from usual connection with another, which is known fact. Presumption of fact is deduction which reason draws from facts proof without an express direction to the effect. Two basic types of legal presumption. Conclusive presumption is one which cannot be refuted by any counter evidence. Disputable presumption is a presumption which suffices until objective contradicted or overcome by other evidence. Two examples of conclusive presumptions. Whenever a party has by his own declaration, act or omission intentionally and deliberately led to another to believe particular thing true, and to act upon such belief he cannot in any litigation arising out of such declaration, act or omission be permitted to falsify it. Letter B, the tenant is not permitted to deny the title of his landlord at the time of commencement of the relation of landlord and tenant between them. Give at least 10 examples of disputable presumptions. Number 1, that person is innocent of crime or wrong. Number 2, that an unlawful act was done with an unlawful intent. Number 3, that a person intends the ordinary consequences of his voluntary act. Number 4, person takes suppress, would takes ordinary care of his concerns. Number 5, that evidence willfully suppress would be adverse if produce that money delivered by one to another that money paid by one to another was due to the latter thing delivered by one to another belongs to the latter, that an obligation delivered up to the debtor has been paid. Official duty has been regularly performed. Number na ba ako? 10. 9. 10. That private transactions have been fair and regular. Who contest the legitimacy of a child born to a wife is no presumption of legitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. What is the doctrine of res ipsa loquitur? Doctrine of res ipsa loquitur. Res ipsa loquitur is Latin phrase which literally means the thing or the transaction speaks for itself. Nakaingat din. Ay, grabe pa.